The Federal High Court, sitting in Umuahia last Friday, struck down Section 84, subsection 12 of the newly amended Electoral Act, which President Muhammadu Buhari had written to the National Assembly to delete. The court, in a judgment delivered by Justice Evelyn Anyadike, held that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever, and not to be struck down as it cannot stand because it violates the 1999 Constitution as amended. Justice Ayadike in the judgment held that appointees of government seeking to contest elections are only required to resign at least 30 days to the date of the election, and that any other law that mandated such appointees to resign or leave office at any time before that was unconstitutional. We are now being joined by Professor Chidi Odinkalu, human rights activist, lawyer, and writer, to comment on this issue. Welcome and thank you for joining us on This Day Live, this Sunday talk show, Professor Chidi Odinkalu.
Good afternoon, Nagman. How are you, sir?
Well, thank you very much for joining us. Well, you just had my introduction, how the learned justice said, well, this is a provision in the Electoral Act that goes against the grain of the Constitution, Section 137, 66, 177, and similar other provisions. But you had written a comment in which you said, well, this looks like the courts of law becoming like sex workers. That sounds contemptuous. But is it an argument that you can sustain, and how and why?
It's an argument I'm happy to sustain, sir. First of all, let me start with this. The job that judges do is a very difficult one. And the vocation of judging is an essential one to the stability of any society. And there are lots of decent judges in Nigeria who do very serious work, very hardworking, balanced people. You may or may not always agree with what they do, but you will uphold and defend their integrity because they're putting in everything. It is for the sake of those judges that we must call out the ones that bring the vocation of the judiciary into manifest disrepute. So let me start with laying it out to you. The case was filed on the 8th of this month, 8th of March, in Umuahia. By originating summons, supported by an affidavit. On the 10th of March, the Office of the Attorney General of the Federation, who is the sole defendant in the case, drew up its counter affidavit and response to the originating summons. They filed it on the 14th of March. That is the counter affidavit. In response to the counter affidavit, all I'm telling you is on the face of the judgment. I'm not manufacturing any of this. I have read the judgment, certified true copy. So I'm reporting the text of the judgment so you understand how serious this is. So the counter affidavit was filed on the 14th of March. But on the 11th of March, the response to that counter affidavit had already been filed, according to the judgment. So 3 days before the counter affidavit was filed, the further affidavit responding to it was already filed. And the judgment was 18 pages, was handed in on the 17th. So from the filing to judgment, you had 10 days. Now, mind you, this is in Umuahia, and then the judgment was also executed, given effect on the 10th, on the 18th of March. Within 10 days, you had gone from filing to reply to response to arguments to judgment to execution. No, the courts don't work like that. It's just straightforward. I could go into discussing the jurisprudence of the decision, but that's another matter. On the face of the judgment, there is manifest crookery. And that is all I can say. Everyone is welcome to look at the document, and it brings the judiciary into manifest disrepute.
Okay, I mean, one of the points you made is about the judgment being corrupt and crooked. In other words, you were saying that the learned justice arrived at the ruling per incuriam. Can you prove further that indeed this was a work of fiction, not law?
Now, let me also say this. In my view, always in my view, there's a difference between a judgment being per incuriam and the judgment being a piece of manifest fiction. Now, when lawyers say that a judgment is per incuriam, they are saying that they're not impugning the integrity of the process. They are, however, saying that the judge may not have taken account of everything that he or she should have taken account of in reaching that judgment. That is human error. That can be a mistake. It does not involve impugning the integrity of the decision. That is not what I'm saying. I'm saying this decision, I am impugning the integrity of this decision. So this is not a per incuriam decision. No. Now, let me also address the per incuriam point. The judgment on its face decides that Section 8412 of the Electoral Act, which is in dispute, is contrary to Section 66(1)(f) of the Constitution. Section 66(1)(f) of the Constitution requires public servants or civil servants in the federation or state to resign not later than 30 days before they contest for political office, before the elections. Section 8412 requires political appointees to resign. Now, earlier than that, the question, therefore, is, are political appointees the same as civil servants or public servants? The judge does not address this question as such at all, nor does she cite any decisions to support the view she takes. And there's a long line of decisions from the Court of Appeal and the Supreme Court which say explicitly that political appointees are not civil servants or public servants. That is the per incuriam point, but that is not my point. And I do this deliberately. I am impugning the integrity of this decision. And it is on the face of the judgment evidence of judicial misconduct that the National Judicial Council must act on and the Nigerian Bar Association must act on. I'm not interested in who wins or loses the argument on the merits, but we cannot continue to run away from holding judges to account when they bring the institution of judging into disrepute. That is my fundamental point.
Okay, but Professor Odinkalu, yes, I get your point. Section 318 of the Constitution defines who is a public servant. But people have also raised the point about the doctrine of the separation of powers. Can a court of law declare an act of the National Assembly unconstitutional? I would like you to help us clarify that.
Obviously,
within the light of Section 1, subsection 3 of the same.
Oh, absolutely, yes. That's not an issue at all. A court of law means since Margaret Madison in 1804, courts in constitutional systems have declared acts of other branches of government unlawful, unconstitutional. That is obviously within the purview of courts. That's not at issue here. No. The question is this decision and the process within the four corners of judicial process, of lawful judicial process? You see, let me illustrate this. Having children is a good thing, but we cannot, for the sake of having children, say we employ sex workers. Yes? Just to have children. And so the judicial process is not an ends justifies means process. That's vigilantism. And what has happened here is an act of legal and judicial vigilantism. Now, the defendant is the Attorney General of the Federation. The plaintiff claims to be a constitutional lawyer in Abia State who is a member of a political party, which is a lawful thing for any loyal citizen to do. And they sue the Attorney General. The Attorney General agrees with everything the plaintiff does not put up any argument adverse to the plaintiff. The judge writes a judgment that shows that all of this was a collusion, in my view, and on the face of the records of the judgment. And they pass it off as the law in the country. That is a crime against the law. Whether done by a judge or by anybody, all of us are citizens. Nobody has a right to bring the House of Nigeria down on top of all of our heads. And we have to fight it.
Well, Professor Odinkalu, let me ask you another question. Some other lawyers have raised the point that the main defect in this particular case is that the National Assembly was not joined as a party to the case within the purview of both Section 4 and Section 228 of the 1999 Constitution. Will you consider that an issue, or it's immaterial?
In my respectful view, it's immaterial. I mean, that's why we're all lawyers. We can differ on that's a zone of legitimate disagreement. But the National Assembly is not a necessary party to this kind of proceeding. And the reason is its job ends at the point where the president assents to the law. Once the president assents to the law has an existence independent of the work of the National Assembly. What the National Assembly can do is oversight the implementation of the law. That's within their purview. But joining them in the proceedings was not necessary to proceedings. And that's not part of what I'm arguing here, no.
Okay, well, is there a winner or a loser in this situation with the,
all of us are.
With what we have? Some persons have argued that the APC is likely to lose because if the case goes on appeal, you could have a repeat of this Zamfara situation. What are the implications of this kind of ruling, both for the judiciary and for the political class?
I mean, all four of us, or five of us in this room right now are losers. Everyone in the country is a loser with this decision. You know what this means? The current governor of the central bank, whose name is being bandied about for good or for ill in this process, can continue to be governor of the central bank until 30 days before the election, having secured the mandate of the ABC party to become its candidate in the elections. Think about the governor of a central bank, yeah, running the central bank of a country and being the candidate of a political party. How would you trust the decisions of that person doing that until 30 days before the elections? It basically means we can prostitute everything in the country and nobody can say anything, and it has the stamp of the judiciary and the rule of law. It could well be that is what the law actually is. But you know, because of the stakes, you need to make sure that the decision and process that leads you to that particular conclusion has credibility and is beyond reproach. That really is my point here. I'm not interested in whether APC wins or loses it. I'm not interested in whether PDP wins or loses it. I'm interested in the consequences for every part of the country. Speaking of an appeal, it's difficult to see how you appeal this. There is one plaintiff, there is one defendant. The only defendant is the Attorney General of the Federation. He has decided that he owns this decision, he loves it, he's been exultant about it, which says all you need to know. Now, there is, of course, jurisprudence to say that an interested party can appeal, but that becomes a matter for academic debate. And the Court of Appeal could decide that the National Assembly, quite legitimate, interested party because its work had finished before this case was filed. And an ordinary citizen is not an interested party. The only way you can do this, because you don't want to set this decision aside and then create precedent that then creates additional toxicity. So we've got to be very careful in how we respond to this as manifestly crooked. And I continue to say that as it is. We've got to make sure we're careful in crafting the right kind of remedy for what has happened here.
Well, Professor Odinkalu, I mean, talking seriously now, the essay you wrote on this, you were talking about political sex workers. And you cited the Gladys Ukeje case, you cited the Mojeku case, and I read your commentary. And I was wondering, what has this got to do with sex workers? If you can provide some enlightenment in that regard.
Well, I'm not yet a sex work professional, but my understanding of the oldest vocation in the world is that is where virtues are traded for quid pro quo, and this really is a problem. First of all, there are several things. The courts are supposed to protect all of us, not some of us. They're supposed to protect all of us equally. But it's now quite clear that judicial system and our jurisprudence has created a practice of protecting only politicians. And if you read that essay, I demonstrate through cases that the courts afford politicians and partisan political cases facilities decision-making that are not available to ordinary citizens. So ordinary widows have to stay in court for 3 decades or more to get property that has been left for them by their husbands or their fathers or male relatives. And politicians spend 10 days to 4 or 5 months in court, going from the High Court to the Supreme Court and back. Now, mind you, this is a Supreme Court that is only assigning now, as we speak, in 2022, for hearing appeals that were filed in 2009 and 2010. Okay? Appeals, 2009 and 2010 appeals are being heard now in the Supreme Court. But politicians like Uche Secondos or Bukola Saraki or whoever else can go from, and these are decided cases, so I'm not just mentioning names facetiously, can go from High Court, Court of Appeal, Supreme Court in 3, 4, 5 months. So that's the first thing. The second thing is that the jurisprudence that is produced in these political cases is just quite frankly marvelous. I mean, you see this particular case in which we've gone from filing to decision-making and execution in 10 days. Now, for you to understand the magic of this, first of all, you've got to understand this is the no more. The process of the Federal Ministry of Justice is every filing has got to be cleared by at least a director in the ministry. And you don't have a director available in Umuahia to clear these filings. Now, you had a response in 2 days, arguments in 4 days, judgment in 10 days. All by the ministry, in which you don't even get response to letters cleared in multiples of that time. Now, but it is also that the jurisprudence is manifestly crooked. You don't do that without evidence of something wrong. And when the virtues of the judiciary get habitually traded like that, I begin to fear that we are approaching or are in the territory of political sex work. That is, frankly and sadly and regrettably, the conclusion I have reached. I am willing to defend that conclusion with everything I have. Because this is a very serious issue. The fate of a country is at stake. And the issues that we've got to confront are very serious. And people are toying with the country, and they are giving us doctrines that don't make any sense for why we should not try to defend issues that must be defended. That is the problem.
Well, points were made, Chidi Odinkalu, but just before we go, can you help us, define the significance of Section 84, Section 12, that the President is objecting to, and this whole process of Electoral Act reform, and the implications for the integrity of the 2023 general elections? The
central problem is quite simple. should political aspirants hollow out assets of the state in order to finance their political ambitions? Okay? So, candidates who are running for office, who are incumbents in high-level political offices, if they continue in that position while running for office, could be tempted to access state assets, whether material or immaterial, tangible or intangible, or to finance their political ambitions. That toys with the playing field and tilts it in favor of one side with the use of state assets. And it seems to me there is a legitimate policy argument for and justification for Section 8412, which is if you want to run for political office, which is legitimate, resign, get out of official state responsibility and focus on that, raise your resources without contaminating the state assets or depriving all of us of access of the benefits of state assets. That really is the justification here. Now, others may disagree, and on that, I'm not a judge. What I'm saying is, if you are going to wade into that particular dispute, political dispute as it is, with the authority of the judiciary, you better do it with manifest credibility, not manifest proof.
Well, thank you very much, Professor Chidi Odinkalu, for agreeing to speak with us on this Lively Sunday Talk Show today. Thank you very much for your insight.